Let's take it back to our panel here. Carrie, one of the things that's going to happen is you'll hear from the state of Mississippi, you'll hear from the abortion clinic lawyer, but the Biden administration gets a say too. What is the administration trying to argue today?
Well, we expect that the administration is going to argue that the United States Constitution does protect this right. We know that Merrick Garland, the Attorney General, has gone out of his way and to try to file a case in the Texas heartbeat bill law. So they want to try to preserve Roe as it stands. But again, as Mississippi said, this is really about giving people more freedom and to understand and to decide how they want their own laws to be in each state. So that the federal government wants to keep that authority completely at the federal level and not let the states determine their own abortion policy.
But let me ask you one other question then. This is obviously under a Biden administration. If this case had come up and we were still in a Trump administration or a Republican administration, how might the administration have weighed in then?
Oh, you likely would have seen exactly the opposite response. And this is something that's pretty typical when we switch over the Solicitor General's office. We've even had cases where they've effectively argued on both sides because Trump's Solicitor General filed a brief in a case, and then later it was argued after Biden took office and the government's position switched. So unfortunately, it's not always taking a position as of the United States more broadly. It's really the position in some cases of the way the administration, the current administration, interprets that.
We may get cut off at any moment here. We'll take you inside the courtroom when it's gaveled to session there. Andy, what do you think Mississippi's best argument is today?
I think, Bill, what they're going to say is that they have incorporated in their statute what Casey says is a defense based on undue burden, so that at least ostensibly you could uphold. They'll try to argue you can uphold the law without necessarily undoing Casey. I don't think it's a very persuasive argument. They really have to confront Roe and Casey in order to.
Wow. So it's the whole ball of wax then, as you're saying.
I think if they're going to get down to brass tacks and really grapple with this thing as it exists, yes.
Jonathan, Senator Shaheen of New Hampshire said that if they overturn Roe v. Wade, you could see a revolution in the country. Is that meant to intimidate or sort of work the refs in this case?
Well, unfortunately, that's just the latest veiled threat against the court and its members. We had a revolution. That's what got us these rights and these institutions. And so it's a really reckless statement, but it's one of a long litany of such statements. I expect it, if anything, would backfire. It's more likely the court will push back than yield to those types of threats. You know, judicial review is supposed to be done without fear of repercussions. That's why we gave justices life tenure. That's what Alexander Hamilton said was the guarantee of the rule of law. And what these members are doing, in many liberal academics, is to say, if you don't rule the way we think you should, you will bear the consequences. Chuck Schumer said that to individual justices. They're threatening to pack the court. That's exactly what the Constitution was designed to resist.
Okay. Jonathan and Andy and Carrie stand by. We can hear the audio from inside the Supreme Court. The marshal is Gail Curley, joined the court in the month of June last year. So we believe now in session, the court will begin. Soon you will hear the Chief Justice and also Scott Stewart, who is the first lawyer to make arguments. Let's drop in.